that out. So you'd lose. Well, you wouldn't like that. We're on. All right. Hi, everybody. We are going to resume the program here. We'll take on the second panel. Paul. We're going to pull everybody together.
Oh, it's like old home week. I'm late to class again.
You were probably late to class in this very room.
This room didn't exist when we were in class, when we were in school here.
All right, so thanks everybody. We're going to get started. My name is Larry Friedman. I'm a partner at Barnes, Richardson & Colburn in the Chicago office, where I practice customs, trade, and export control law. So the second panel is going to pick up on a number of themes that started with the first panel. As I often say, there's a lot of trade policy in the world and there's a lot of trade law in the world, but where the rubber hits the road and people start writing checks is when your goods cross the border, and then that's the customs law. So we're going to focus on some of these issues and some other issues and talk about what's happening with companies and what's happening with customs and how people are adjusting to some of these issues and other changes. So we have a great panel of speakers for this purpose. I'll introduce them briefly. They are all well known in their fields. Next to me on my left is Sandra Bell. Sandra is a partner at DLA Piper. She comes to this panel with, I hope you'll allow me to say, over 3 decades of, I said it, so, of customs and trade experience, particularly with the government rising to the level of Deputy Assistant Commissioner of Customs and Border Protection, where she was responsible at various times for heading, I always call OR&R, but now we just say regulations and rulings, and also regulatory audit. So in that capacity would have been interfacing directly with the issues that we're talking about today. To my right is Richard Wortman, who, as we said, is a graduate of this fine institution. He is a partner at Grunfeld Desiderio
At all.
LSK. So where he practices import and export law, trade regulation, and advises clients on matters such as tariff classification, rates of duties, valuation, country of origins, penalties, seizures, and all the other things that can happen to merchandise. To my left is Paul Vandevert. I should have done this beforehand, Paul. Tell me how to pronounce the name of your firm.
Occam Trade Law.
Okay, so he is a principal at Occam Trade Law, and had previously, as you heard earlier, been international trade attorney at the Ford Motor Company, where he spent 17 years counseling Ford Motor Company with respect to customs and trade compliance, and therefore has a wealth of experience from an in-house perspective, and now is developing experience on the outhouse, which is not the right way to say that, side of things. So, sorry about that. A couple of things that have been, we're going to get to a lot of the intersection of some of the things that Judge Kelly talked about and the trade issues that were on the previous panel. One thing Judge Kelly mentioned was the Tobacco Stay-Wilson case regarding deadlines for customs to issue drawback regulations under the TIFTIA. So there is a tremendous amount of jargon in our field. So I know we got a room that's about half filled with students. And I will quote my friend Amy Porges, where'd you go, Amy? Who says that drawback, which what I'm about to talk to, is incredibly boring and arcane unless you use it, and then it's very important. So we're going to start with drawback, and I just want to talk about a few bits of vocabulary, which, and then we can get into this. So for those of you who may not know, drawback is a statutory creature. It allows an importer who pays customs duties and excise taxes, although there's some issues there, upon the exportation, or some cases destruction, of that merchandise or substituted merchandise, and we'll talk about this a little bit, to get a refund of 99% of the duties, taxes, and fees that were paid. So the point here is basically to encourage the importation of raw materials and parts and production materials, have something done here to them, export that, and then you get the credit basically back for the import duties. There are a lot of nuances around that. In some cases, merchandise is imported, not changed at all, held in inventory, and then exported. That is what's called unused merchandise drawback. That is contrasted to manufacturing drawback, which is where something comes in, is used in manufacturing, and then the manufactured item is exported. And then the third sort of nuance around this is that sometimes the imported product is not necessarily the same product that is exported, but you have substituted a commercially interchangeable product for it, regardless of where you got that from. So there's a lot of record keeping. There's a lot of compliance concerns around drawback. And as the court case that was referenced earlier talks about, there was a change in the law that required new regulations. So maybe, Sandra, you can just give us an update on where we are with respect to the regulations?
Okay, well, the regulations actually are still in they call the internal review process, but being where I am now with the law firm and not with the government, thank goodness for the Court of International Trade, a deadline has been set by Judge Rastani for those regulations to be issued by December 17th. This is the first time I've ever seen that, where you actually had a court challenge to regulations before they actually became regulations. And in terms of you having two decisions coming out, interesting that, and the second one where the court, pointed to a provision in the APA that hardly ever is used. I guess the government's claim that they had to use a mandamus to force an action that the government should take with respect to promulgating the regulation. But this is not the first time the government has ignored timelines in laws. They sort of do it routinely, but this is probably the first time you had someone actually suing to compel them to meet the timeline. And by the time they filed suit, the timeline had already passed. The regs were supposed to be promulgated since February 2018, and the lawsuit was filed, I think, around April, and maybe a decision came out in June in connection with the preliminary injunction that was sought. And the only reason why the lawsuit was filed was because the law, first of all, you can't get drawback. People are just filing claims for drawback now. They can't be processed under the new law because the law requires that you have a regulation to establish the calculation for the drawback to be paid. But under the old law and under the current regulations, importers and anybody filing had this procedure to be able to get the payment before the drawback claim was processed. It's called accelerated payment of drawback. That's a regulatory creature. That was not a statutory creature. There was no right to get that in the law. So because of that, people were hurting because they wanted to file under the new law. It's easier. We'll probably talk about that in a minute. And, here they are, can't file, get a claim fully processed, and even worse, can't get that accelerated payment where you have a lot of cottage industries, building up a practice, especially customs brokers, and operating on that flow of money coming in under drawback. But I just wanted to mention, just passing, in reference to drawback, when Larry first mentioned we want to cover the process of drawback, who wants to hear about drawback? This was back in, early June or something like that? Before that, maybe like May. So lo and behold, then we have 301, we have 232, and here we are. We have companies now asking about drawback. Because interestingly enough, and I think this may be something the students may want to look into, no drawback is allowed for Section 232 tariffs. That's stated in the proclamation, the amendment of the first proclamation. 301, however, it wasn't precluded, and so CBP's issued several guidance documents that says you can file drawback claims for the duties that you're paying under Section 301 for the tariff. So a lot of companies are now interested in drawback. So it becomes a very relevant area, and then it's also good the fact that it is in the reform drawback where it's easier to make, and so the status is people can file the claims, but they can't get the payment under the new drawback provision, and they certainly can't get accelerated process. So hopefully that's something that will, the government will not be held in contempt and follow Judge Rastani's order, which is December 17th, and where the final regulations are supposed to be sent to the Federal Register and made effective that date. But the order, interestingly enough, this proposed rulemaking includes not only the implementation of TIA, the new drawback statute or amendment of drawback statute. It also includes an amendment that the Treasury Department has been trying to get for at least 15 years, and that is a regulation that precludes what they call this double drawback in connection with excise taxes. It's excise tax imposed on a bunch of things, cigarettes, tobacco, alcohol, wine, and domestic as well as imported. And so in connection with wine, CBP had ruled, I guess back in early 2000, maybe 2004 or something like that. Not rule, no, San Francisco office had done it. It wasn't a ruling. And CBP tried to modify it, and then it was a hue and cry, so they backed away from it. So this is like using this vehicle to get in something that they wanted to get in for a while. That's tied to the new drawback regulations, and I think Judge Rustani wisely, instead of making that effective immediately, upon submission to the Federal Register notice, stated that the government can have that delayed effective for 60 days. But we can talk about that in a minute, but that's interestingly not under TIFTIA, under a pre-existing provision in the drawback law that really was sort of never used for regulations, and the government made a very substantial analysis of the background on that, so it'll be interesting to see whether that's challenged later on, but I think it's going to be a heavy lift to overcome the rationale, at least on the administrative procedure process. So I know I segued away from that.
No, that's fine. So, Richard, you want to talk about some of the highlights that are in the regulations? What are the changes that are going to come into effect?
All right. So there's good news and there's bad news. And probably the best news for many importer-exporters is that you were allowed in your lifetime one exclusion. You're allowed a one-time, once-in-a-lifetime exclusion where you don't have to give prior notice. Prior notice is where you tell customs, we want to export these goods, please come and examine them so that we can export them. You're allowed one exclusion. Well, up until TIFTIA, there was a 3-year look-back period, and you could get 3 years worth of drawback had you not claimed drawback. There are many companies who either don't know drawback exists or it's just too much paperwork, I can't be bothered. Well, today, all of a sudden, it's become a huge cottage industry. There's a lot of money passing through. TIFTIA changes that 3-year look-back period to 5 years. So that's the good news. The bad news...
Can I just interrupt for 1 second? What's TIFTIA? We keep saying it.
Trade Facilitation...
Trade Enforcement Act.
Trade Facilitation and Trade Enforcement Act.
2015, right.
Right. I've been saying it for so many years now that I honestly don't remember. But I felt the same way last year when I talked about EPA. So we now can look back 5 years, and that's a great thing for many industries. Like all other regulations, the devil is in the details. And here, the devil's in the details are, first of all, up until TIFTIA, the final regulations are put into effect, and that's through this window period that began, in the words of Don McLean, the day the levee went dry, February 24th of 2018, that you could file drawback under the old statute, that's called core drawback, or you could file under TIFTIA, which allowed you the longer period, but you had to file it electronically through ACE. ACE, for those who need vocabulary, is the automated commercial environment. And that's the way customs brokers and importers who file directly file their information with customs. ACE is a system that customs has spent almost 20 years developing. They're many billions of dollars over budget, and it works at probably from my opinion, at a 20 to 25% capacity. Others may disagree and get it up to maybe 30%. I don't think anybody's thinking it's the end of the world. But the real question is what's in the details. One, if you have a ruling out there that allows you a manufacturing process, you have to update that ruling. You can't just live on the ruling. You may have been doing the same process for the last 30 years. You need to update that ruling. The same is if you have permission, a waiver of prior notice. You must also file to upgrade. Sandra mentioned the worst consequence from my point of view was that during this window period, starting in February, there's no accelerated drawback. I can tell you personally that I know of at least a half a dozen customs brokers who are on the verge of bankruptcy at this point because their whole business model was based on doing all the paperwork, collecting all the data, and obtaining a percentage of the return. But they don't get paid until there's a return. And so for this 1 year period, there's a lot of duty that's not being refunded. Probably the biggest change for those who participate in drawback is how you calculate it. There are a whole series of rules which I don't want to get into the weeds, but suffice it to say, historically, I would analogize drawback as you would go to the bank. You had a bank of imports, and you withdrew whichever import you wanted, and you matched it up to the export, and you sent it out. And it was really simple and straightforward. It was a lot of work. You had to keep a lot of data, but it was very simple. You could match imports and exports. The interim guidance created several different methods. So for substitution drawback, which Larry mentioned, goods go out, but goods come in, and then we substitute, for example, American. So you bring in you import 1,000 sweaters, but then you substitute 1,000 American-made sweaters and you export them. You can get 99% of the duty back. The right to drawback, by the way, is transferable, so it doesn't necessarily have to be the same party who imported them who may obtain the right to the drawback on the way out. And that becomes very important in a lot of industries, including the wine industry and the wine and alcohol.
Petroleum.
Wine, petroleum, alcohol.
Actually, at least with the same tariff code provision,
Right.
it actually had a broader applicability. I just want to jump in quickly. For example, in the automotive industry, if we import vehicles under say 8703/21, and we export a different vehicle, but it has the same tariff code, Ford would be entitled, or the automotive company would be entitled to draw back the duties paid on the imports. And there is for the automotive industry.
The auto industry is the reason for the lesser of rule. I remember that discussion.
Yeah,
Import Mercedes and export Volkswagen. So
Yeah.
basically the value, what you get back would be 99% of the lesser.
No offense to Volkswagen.
Well, which leads me to my next point, which was the lesser of rule, which is for manufacturing, unused, direct identification drawback. If you think about that bank, you now have to select the lesser of, in other words, the lowest possible value, and work your way through the chain, which is a major change for many companies that may export, but not export 100% of their imports. Probably, from my point of view, Sandra touched on this, I'm going to call it the award for disingenuousness, is customs alleged loophole about excise tax. Excise tax on alcohol is collected upon importation, and also excise tax is collected for domestic product if it's put into consumption in the United States. But until it's put into consumption, you don't pay the alcohol excise tax. No different than that sweater example I did before. You pay duty on sweaters that come in, but no duties are ever paid on sweaters that are made here. And you can substitute them and export them. Well, under the proposed rules, this would eliminate the excise tax because it's being characterized as a double drawback. I don't personally, I don't get it.
The excise tax on the import?
Today, if you import 1 million gallons of wine and you export 1 million gallons of domestically made wine, which no excise tax has been paid, you can get 99% of that duty paid on, the excise tax paid from the import. And so what we have in our firm do is we don't do the drawback itself. We refer all this to drawback brokers. But we have domestic clients that we've partnered up, importers and exporters, and they share that drawback. And it's a business arrangement that has been working for, I've been doing this over 30 years, and we've been doing it for quite a long time. So I think that those are sort of the major, somewhat in the weeds, devil in the details that we should be looking at.
So I will say, well, first of all, it's not my job here nor in life to carry water for customs, but I will for a second. And on this excise tax thing, the problem that they're perceiving is that the domestic industry is paying the exact same excise tax when they sell domestically, and they have no way to, if they're not exporting, if they're not importing, right? So you're just a California winery, right? I don't mean just, but you're a California winery without imports to offset your excise tax. You're stuck. I don't know why they're calling it double drawback. I don't get that.
I get that part, because basically under the tax law, they say that liability attaches when it's manufactured. It's just being withheld from payment. And so if you get to export that product without paying it, they look at that exportation as like an extinguishment of tax liability. So that's a drawback upon exportation of that domestic-made product.
So they're defining drawback in a new way and saying you're
right, not the typical,
I mean, I think that there's potentially a constitutional argument that the excise tax on an export is a tax on an export.
I think they got harbor maintenance.
Will you do that on a contingent basis? Are you that confident? All right, I want to move on. The discussion in the last panel about Section 301 duties in particular and the impact on people who have a supply chain that extends to China has put a focus on a number of compliance concerns that customs lawyers see. There was mention on that panel about the rush to reclassify merchandise. I want to come back to that later on. We talk about that as well. But the other thing that's happening is people are either looking for ways to engineer their products engineering comes back to classification, but looking ways to change their supply chain to move products out of China or to take partially completed products to a third country and do something there and change the country of origin. So Paul, can you talk a little bit about how country of origin is determined and what the rules are for deciding whether something is a product of China?
Yes, although I wanted to start because this recent spate of 232 tariffs and 301 tariffs have woken up many companies that there is such a thing as customs and that there is such a process by which import duties are paid. Even companies that were doing some importing but had relatively low tariffs applied to their imports or didn't have a high enough volume are suddenly waking up to very significant impacts on their business. But what it brings back to is there are some fundamentals of customs that most of us, aside from those that make our living doing it, have always rolled their eyes at when you get into it. And so there's essentially 4 or 5 things that anyone importing a physical good must tell the government. They must tell the government they must tell them what it is, what it's worth, where it came from, and well, that covers actually basically the essential information. There's usually some kind of additional information, but those 4 basic questions have to be answered every single time an import in. And so the 301 tariffs have simply caused companies to pay more attention to those questions, but they've been questions that are there and are done every single time something enters a country. And this isn't limited to the United States. I mean, our issues and discussion is limited to the United States, but that's a global truth. Those 4 questions need to be answered. So on the country of origin, and I'm going to deviate a little bit because there are the fundamental thing of a country of origin is the last country in which a good was substantially manufactured or processed. The determination of that is a much more subjective analysis. In the United States, we apply what is called the substantial transformation standard, which it's interesting. I for long years was kind of critical of it because it can be analyzed and discussed in a myriad of different ways. And to be honest, is sometimes subject to, and it's of relevance here, can, like other standards, be subject to overriding policy concerns. So you can kind of come to a conclusion, and it can either be inconsistent with the way you've done it before or not. But and there are some tests that you can do. But the other one, another helpful definition is the European standard, which is adequate processing or manufacturing. But fundamentally, what it is I've not been thinking that this is a terribly complicated question, because about 2 weeks ago there was a front page article in the Wall Street Journal talking about all the efforts that people are now trying to do to avoid the 25% tariffs. And what they said is, well, we'll just send it to Macau, and then it won't be China anymore. Well, if you go back to this fundamental definition, did you do anything to it? And then there is a category of not doing enough. But if you didn't do anything to it, if you literally just took it from China and moved it to another country and then imported it into the United States, personally, and all 3 of these people know how much that I love to make an argument, personally, I don't see what the question is. It's from China. That's where it was made. That's where it was grown. I mean, the article actually focused on wood, which is really, I mean, yes, you can further process it, but it's wood. It came from a forest in China. And if there isn't a forest in Macau or in Pyongyang, one of the islands in Indonesia that they're also suggesting, I think you got a problem. So there are some basic things about country of origin. That doesn't mean, which is the second point that I want to emphasize, what this whole year has done is cause companies to look at their customs operations and to actually treat them as a thing. I mean, a thing that impacts their business. And I'm seeing, and I think many of my colleagues are, instances where maybe not so much country of origin, but even things that, oh yeah, we've been doing this for years. And is it really from China? Did you forget about the factory in Mexico, say, or where something really substantial is done? Does it mean that the country of origin will change? No, but it is something that you should be looking at. And then more particularly, or more, at least for me, more common is classifications. Oh, we've been using this for years, it's fine. And now it's not. But for the students particularly, the fundamentals still apply. There's no new set of rules that are coming into play, or no even new principles coming into play just because it's 301 or 232 tariffs and they're 25% as opposed to 4% or 3% or 2.5%.
So if I can just pick up on that. So Richard and Sandra, for your clients, when they're coming to you, hopefully they are coming to you and saying, all right, we've got a new supplier now in Malaysia, so I'm out. What are your expectations, or what's your advice with respect to diligence, and how do they determine whether, as Paul pointed out, it's just a Macau transshipment as opposed to, yeah, there's a factory in Malaysia that's making this stuff? What do you think your clients should be doing or should they be doing anything to confirm that? Do they believe their supplier?
They have to know their supply chain, first of all. Most clients do. They know the supply chain. That's because that's where the money's coming from. But what they generally don't know is the operations in each country in connection with the supply. So if you have a product that's manufactured in more than one country, one part's done in China and another part's done in Taiwan, they may have the most sophisticated and expensive part being done in China, and just relatively small, minor operations, packaging and adding a few things, putting together a few sub-assemblies in Taiwan. That's a situation where, okay, it didn't matter that it was a product of China. But that's a situation where they have an untapped opportunity to effect a change in an operation and just turn over more operations to Taiwan that would have been in China without a lot of expense, and then change the country of origin. But they have to know that operation initially, and they have to sort of know where stuff is going. You have situations where companies are, like you just mentioned, manufacturing. Maybe Paul mentioned that they're manufacturing a lot of stuff in China, and then they're shipping it to Mexico. Not realizing, well, you can actually put more of that operations in Mexico and then make it Mexico.
And I want to say, I mean, I've had an actual example where the company was unaware of the significance and degree of what was being done in Mexico already. Right. So there's two things. I mean, the first thing to look at is really get a clear understanding of exactly what you're doing and where. And probably only a very small number of, questions will be resolved by that, but it's absolutely critical to do that first before you begin discussing, is there something that we can change?
Right.
And then, of course, both still apply to, if we're going to change something, it still has to be substantial enough. You can't just move the for example, if you say, well, we'll move the packaging to this other country. No, that isn't enough, because you haven't changed at all the thing that is really being imported.
But the sort of assumption built into what both of you guys are saying is that you've got some control over the supply chain. What the question I was raising is maybe the smaller importers and also like retail companies where there's high inventory turns. You're just buying shirts, right? If you're buying undershirts that are pre-made by a supplier, you don't control their factory, you don't control their supply chain, you don't know. What you know is you've spec'd a product and they said it's no longer coming from China, it now comes from Malaysia. So if you're the retailer who is unrelated to the supplier, what I am concerned about what level of, just so for the students in the room, at a minimum, the obligation of the importer is to exercise reasonable care. I'm curious as to what reasonable is in an environment where duties have gone from relatively low to maybe 25%. So there is a high revenue impact,
Larry,
and a potential high liability.
If I might, in some respects, I would go back to, I've often talked with people in my career. On a basic level, don't lose your moral compass. And so, and I mean that very seriously. So if you're a retailer, and you could be a small store, and you've been getting imports, and you were the importer, which is also a big difference. But if you're the importer, and those products had been coming from China, and then suddenly you get a note or you get a shipment and the very same product is now from a different country, you need to question that. You can't just say, oh, it's my lucky day. Oh, good. I wasn't impacted by the 25% tariffs. And I actually am going to, when we talk about 25% tariffs and, oh, I was suddenly impacted, I am going to inject here a personal note, and I mean no offense to anyone. Don't get mad. Don't get frustrated. Vote. That's it.
All right. I think that, I represent from small mom and pops to Fortune 10. And, at the end of the day, we start with trust but verify. And you need to verify to meet reasonable care. But no matter how good you are, you may not be perfect. And I can illustrate this in a very quick story. When I was a very young lawyer, I got the trip of a lifetime. I was sent to Mongolia to go look at a factory so that we could prove to customs that certain goods came from Mongolia. And we went and I visited the factory, we videotaped the factory, we went through all the books and records of the factory, and we came back with a lot of information. I then went to Philadelphia to meet with the import specialist where these goods were going to come in, and I did my dog and pony show, and a week later the first shipment came in from Mongolia, only to be seized by customs. And when I called that import specialist, she said, you may want to take a train ride to Philadelphia. So I went from New York to Philadelphia, and she had a videotape of the container being moved off a feeder vessel from China with zoomed in marks of the seals on the container. It was the same container that magically went from China to Mongolia to the United States. The truth is, there was no way the importer would ever know that. I mean, they did their due diligence, and the goods were still were toxic. You have to do whatever you can. Some importers have taken to buying goods landed duty paid. Not my problem. You import them, you land them, and it's not my problem. Traditionally, and I say traditionally meaning up until recently, with one exception, customs has been pretty lenient on LDP buyers. LDP stands for landed duty paid, or DDP, delivered duty paid. Those are variations on the Incoterms, and thus someone else is responsible. The problem is that if you cause the importation, you're equally culpable under the law. So even if you're going to buy goods delivered duty paid, you still need to know your supply chain.
Right, and customs knows that in a lot of these DDP transactions, delivered duty paid transactions, the importer is a foreign entity. They're operating in the United States as it's called a non-resident importer. There's a bond with a surety to secure payment up to a certain point. But in a lot of cases, customs will tell you, once there's a problem, that entity disappears, and the ability to collect there is no ability to collect from the actual importer, and there is therefore an additional focus on, well, who was involved in this transaction? What did they know? When did they know? Did they exercise reasonable care? Did they make any affirmative statements to customs that might be incorrect? So there's a lot of potential for liability there. I can just tell you that, particularly for the students, there's getting to be a little bit older case now at this point. There's a case from the Court of International Trade called Golden Ship Trading. Person was importing T-shirts, actually, speaking of shirts, from Haiti, getting them into the country duty-free under a privilege for Caribbean countries. Turned out that they came from China, and I think it was just the sleeves were stitched on in Haiti. But the point there was that the woman who was the defendant, the principal in the company, had not visited the factory, which was a big consideration in the case. And then there were some other facts, speaking of Paul's point about not losing your moral compass. Also, don't blind yourself to what's happening. I mean, the exporter, she met the exporter at a trade fair, I believe in China. It was a Chinese-based company, but they said, no, we've got this factory in Haiti. So, Richard's point, it's not always just it's not what you know to be true, it's what you can prove to be true is the important thing. So, all right, let's move off of that and make sure we've got time for questions. Another thing that's
actually, and there's a difference between what you know and what you want to believe.
Right, right.
And want to believe is not going to work if it contradicts the facts.
What you want to believe because it's in your business interest is not the test for reasonable care, which is too bad for those of us on this side of the bar. So there's a lot more that is sort of flowing out of the environment we're in with a bunch of new tariffs and the enforcement environment that is built around that. One of the interesting things has to do with what's called the de minimis level of trade. Richard, I think you wanted to talk about this and give us a little bit of background on low value shipments.
Sure. So in short, somewhere in the 1940s or so, the post office went to Congress and said, we don't want to be bothered making entries, formal entries to U.S. Customs. And Congress enacted this small section, Section 321 of the Tariff Act of 1930, which says a de minimis value does not need entry into the United States, and you just merely have to present a manifest, and the goods are cleared and enter the country. Over time, that limit increased, and I believe in the 1970s, it went to $200. That $200 limit stayed until TIFTIA went into effect. And that limit is now $800. The reason for it, the limit increase was pushed by the couriers, FedEx, UPS, and DHL, because they didn't want to have to make formal entries on all these packages, all these millions of packages coming in every day, or at least a large number of them. What has happened is that 321, there's the good side and the bad side. The good side for practitioners like me is that we have used that as an opportunity for our clients to open warehouses outside of the United States and lawfully avoid hundreds of millions of dollars of duty by bringing in, rather than bringing in goods wholesale to the United States, selling it at retail here, you go online and the shipment comes from Montreal rather than, Columbus, Ohio. Do you care? It came within your 24 to 48 hour window. It came with the same return policy. You don't know, and you don't care where it came from. In the meantime, each of those individual packages may not be a lot of duty, but if you take it in the aggregate for, a billion-dollar retailer who's a third to a half of their business is now online, all of a sudden you're talking about 50, 60, $100 million of duty lawfully not paid. So that's kind of the good part of it.
And can I just clarify one point? Is that if you are staging this in Canada or Mexico for shipment to the U.S., you're probably avoiding duty in Canada and Mexico too.
That's correct.
You're not
because
paying,
of other very favorable laws in those countries.
Right.
The flip side of it is what nobody ever thought about when this de minimis went up, was that all of a sudden the number of packages would go from somewhere between 80 and 100 million units a year to the last count was somewhere between 6 and 800 million a year. They're not covered at the moment. They are not done. They're not necessarily all done electronically. There's a very limited ability to screen them. In fact, things coming from the Canadian and Mexican border, there is no even pre-notice to customs that the shipment is coming in. The truck driver is the one who's making the decision, does it qualify or not. The truck drivers have gotten very smart. Everything's worth less than $800. They hand them a stack. There's 4,000 packages in a box. Here's the invoice. Here's this. And customs has to make a 30-second decision. Do I pull this truck over and start inspecting 4,000 packages, or do I let it go? And the answer has been more likely than not, we're just going to let it go. In today's environment, Customs is looking for, their mission includes, stopping drugs at the border. interdicting opioids especially. They're supposed to be addressing intellectual property, although I am told by various port directors that that's kind of gone to the wayside in the individual package environment, only because opioids are the big deal. But really, the unintended consequence of this has been this mass migration from traditional customs entry into the small package environment.
Which, this is a big deal for the couriers. It's a big deal for the e-commerce companies. It was a big deal as part of the U.S. Mexico-Canada agreement, trying to get equalizing the level of de minimis shipments to in part to facilitate this.
Oh wait, I should mention one thing to tie this to the last panel, is that if you come in and de minimis under $800, you're also exempt from 301.
Right.
So industries that are subject to 301 duties are making a beeline to divide their shipments up into nice $795 packets.
And an interesting fact about this is because of the recently negotiated United States-Mexico-Canada agreement, they did not adjust. The U.S. limit is 800. Going into Canada, it's like $40.
Well, going into Canada used to be $20 across the board. It is still $20 for postal shipments. It is $40 for courier shipments, and for traditional shipments, for traditional freight, it's $150. However, you still have to file a full formal entry in Canada, and before, it used to be exempt. If it came in individual packages at $20, it was exempt from provincial sales taxes and VAT. It is now subject to VAT and provincial taxes, so that $150 will actually cost you about $50 to get it in. So what Canada gave, it taketh away in large part.
The United States is now threatening to actually lower its level from 800 to force Mexico and Canada to raise theirs,
It's not going anywhere.
But that requires legislation, so it's not going to be part of that negotiation. But one thing to keep in mind is that the 800 was raised from 200 to 800, but the exemptions from the original 200 still remain. So you still can't have anything that's subject to quota. You can't have any of the alcohol, tobacco, anything subject to excise tax. So those things still require a formal entry, even though the amount may be $800 for duty purposes, it's not affecting the filing of entries for those things.
So we've got some other topics that are basically just things that are bubbling up on the customs side, but we're about 10 minutes out, so I want to give the audience an opportunity to either ask questions or comment on anything we've talked about. Matt?
Got a couple questions on rules board in regard to NAFTA. There's some odd rulings out of CBP with regard to 232 versus 301. Apparently they're applying one rule, they're applying normal rules board in NAFTA rules board for 232. They're applying substantial transformation for 301. Is that correct?
I think that one on 232 probably will be reconsidered because that was a New York ruling, the same way the first one on 301 was a New York ruling that headquarters ended up modifying. So I would.
So do NAFTA rules apply?
No,
which
is
don't
just
the opposite.
So just so everybody's clear on this, sorry, I was going to give a little background and then the panelists can talk about it. As Paul mentioned, the sort of normal rule, absent any other regulation or statute, is substantial transformation. Has the product changed its name, character, or use as a result of production in whatever country? Under the North American Free Trade Agreement, there is a very specific set of rules for determining which of the three countries or the country of origin of goods from a NAFTA country. So if you have goods coming from Canada or Mexico, you apply these regulations, which are based upon the tariff classification of the inputs and the tariff classification of the output. They create a very objective, non-subjective test. And there was a ruling, and those rules, to Matt's point, have been applied in previous rulings for country of origin questions for things like anti-dumping duties, and there was a ruling issued in, I think in July, under 301, where Customs applied the NAFTA marking rules, the origin rules, to goods coming from Mexico to determine whether this motor that was assembled in Mexico from Chinese parts was of Chinese origin or not. And that was revoked recently. So headquarters got to that. And in the ruling from headquarters, it said, I'm going to quote this because I'm glad you asked this question, when considering a product that may be subject to anti-dumping, countervailing duties, or other safeguard measures, which I think is probably not the best word to use. Safeguard is a very specific meaning. The substantial transformation analysis is applied to determine country of origin.
Do you think that word safeguard means 230?
Well, I bet that ruling in 232 will probably be modified or revoked.
Here's the thing that I wanted to point out, and maybe, well, actually it's for practitioners and law students as well. I wanted to pick up on 2 points. One was the discussion that Judge Kelly was talking about on the Chevron thing. There's once the gap or the ability of the agency has been resolved, one of the next steps is the amount of deference that is to be given to the agency based on their expertise. And one of the standards that, to be frank, has been applied to Customs quite a bit is essentially the degree of articulation to their rationale and to their thinking, and the phrase, the applicable test, is the power to persuade, and that's me.
Good boy.
Yes.
Good boy.
Yes, Your Honor.
I've written this and it's published under my name, so I don't feel like I'm giving away
Yeah.
my judicial philosophy. But I call the power to persuade persuasion.
Yeah.
That would be a good use of English.
The two are often related. I mean, it starts with the agency saying you should just go with whatever we said, and then the next step seems to be, well, as you actually were talking about, if I can understand your rationale and you supported it. And what I would say about the headquarters ruling.
I would change that a little bit. So I think I look at deference in terms of if there are a range of choices, there are a range of reasonable choices. If you chose one of the reasonable choices that I might have chosen something else, then because of deference, I need to accept your choice. Actually, some scholars call it Chevron acceptance. Once you determine that there's been a delegation and that the choice made is reasonable, you just accept the choice. The problem is with the words we use, they're loaded. So we say the word deference as if, no, I'll go ahead and make the choice. And that's why I have a problem with calling me deference, because I'm not saying you make the choice. I'm saying you persuaded me based upon your expertise, how many times you've done it before, how well you've explained it. You've persuaded me. But the reason why I think it matters is that when you use a word like deference, people read other understandings into them, and that's when you get to the point where you have somebody arguing to you, well, Congress decided it, so they get deference. That doesn't mean anything. So that's why I just want to make that.
All right. And the point's well taken. The point that I wanted to make is I've read the ruling. I've read it now several times. And while what Larry said is in the ruling then actually does nothing to address whether or not one substantial transformation actually occurred on the facts, and then actually decides. The ruling is actually modified by disagreeing with the NAFTA origin rule that the New York applied, and they apply a different, and headquarters applies a different one. So where I go to the power, the persuasion, you're right. I would seriously doubt. I'm learning the practicalities of being in private practice. I won't take this on contingency, but I would give a client good chances to challenge that ruling, probably in court. I mean, headquarters has already said where they are. And the other thing is, in one sense, in customs defense, this is policy-driven decisions. This is not something where they're actually really engaging in an objective or sort of out on its own issue of whether or not there was substantial transformation.
That should be challenged if that's the case. If we have any kind of information to support that, it's supposed to be objective.
It is supposed to be objective, but the fact is that I think the rulings you're seeing, especially also the speed in which these rulings are being made, are to cover the government's position that the 301, we are going to collect the 301 tariffs. They are going to be impacted.
All right, but I think that to kind of wrap this up, I personally believe that what the ruling tells us is that this is a trap for the unwary. You may not, traditionally we did one analysis. If it was a NAFTA product, we did a NAFTA analysis, we made our decision. Does it qualify, A, to be NAFTA? B, maybe it doesn't qualify for NAFTA, but it needs to be marked made in Mexico. It may qualify as a Mexican product, but it's not to be marked in Mexico. Or third, it doesn't qualify at all. Here, what this ruling is telling us, at least on its face, is that if we're in a situation where we have 301 duties looming, that we have to do two analyses. We need to first look at the NAFTA analysis to determine origin, but we also have to look at origin under 301. Now, besides being the...
and wait a minute, this ruling did hold, it's really important. This ruling held the product is to be marked made in Mexico to pay 301 tariffs on China.
On China.
Exactly.
Right. It is possible, I think it is possible you could have a NAFTA originating product which is not subject to the MFN duties, the normal duties, and still end up paying 301.
Exactly.
Right.
And that's the trap for the unwary that I'm concerned about from that ruling.
Judge Gordon, did you have a point you wanted to make on persuasion?
It's just about difference is the consequence. It's the result, right?
Right.
And that's important to remember. And to Judge Kelly's point, words matter. And it's very important when you're arguing for the court to understand the words that you are arguing about. Because it is very easy to basically, be that returning spaceship and bounce off the atmosphere and end up in a place that is totally unintended because you don't understand the words that you're arguing about. So, equation gets you to the consequence, which is different, right? So it's important not to confuse the purpose and role of each one of those phrases, those words.
But deference, and I wasn't, Judge Kelly, I wasn't being flip about saying that was a good use of English, because it does matter, and there's also obviously tendency lawyers have to needlessly make things needlessly complex. But what you're saying, Your Honor, is that and Judge Gordon, the deference is the consequence of persuasiveness. And is that the same as what you were saying, Judge Kelly? Or were you saying that deference is different than whether something is persuasive?
Word out of play, that what you end up is accepting the
Because you've been persuaded. Right. Understood. Okay. Other questions? Other topics? I mean, I will say for the students who are interested in sure, Zach.
Sure. Is there some talk about duty avoidance? You were talking about drawback. You were talking about informal entries. What about, if I'm a manufacturer, and maybe my products, my inputs are all on the 301, the third list, and there's no exclusion process. When do I start looking at, use of foreign trade zones?
Last year. Well, foreign trade...
No, you can look at foreign trade zones anytime. Found warehouses if you're planning on exporting the stuff, but it only serves a purpose if you're planning on exporting the things after importing them from China. If you're planning on importing them into the U.S. for consumption, neither one of those facilities will get you out of paying duties.
Right, but I think
it may delay your payment, but it's not going to affect the 25%.
Even if my finished product enters under a different...
No, because the inputs are from China.
The China input has to be, I always get these
Privileged.
wrong.
It's privileged. It's privileged status when
The
it
rule's
goes
been
in.
specifically changed for that,
Yeah,
is
yeah.
that the designation of the imports from China must remain identified as Chinese origin, subject to the 301 tariffs.
When you bring it
There's
in.
no tariff conversion.
All right. I think the other piece of that is classification, valuation. I will say, at least in my office, and I'm sure it's similar across the board, we've been trying to talk to clients about classification for decades, and nobody is like, no, it's 2%, leave me alone, it's fine. All of a sudden, people are asking us, oh, well, maybe we need to reclassify this a different way. What we have found, frankly, is that more than 50% of the classifications we've been asked to examine are actually incorrect. So it's been a very interesting time.
So when the duty rate goes up because of reclassification
Right.
of 301,
Then you gotta look back.
or are you going in for ruling or a prior disclosure?
Well, I think prior disclosures are going to become key, and I think it's also important, even if you've got a situation where you go from 0% to 0%, because you want to have used reasonable care. It's going to overwhelm customs, but sort of everything overwhelms customs.
Also, reasonable care doesn't always require getting a ruling or require a prior disclosure. The other thing that I would say is, and it may be the same as a shameless plug, but this classification is something that, especially for clients, and I'm going to say it sort of humorously, which is, don't do this at home. All of this has been with professionals on a controlled track.
Don't do it at home, and don't let your supplier do it for you.
Right,
Which is
right.
the other thing that happens all the time.
So the thing is that if you're thinking about classification, it's a legitimate question. As Richard made, is actually the opportunity to look at your basics. But people shouldn't be doing it without knowing that they've got good, experienced, expert advice in what you conclude.
So we need to wrap up. I think the takeaway note is there is danger out there. There is enforcement of all of these things. Customs is aware of all of the risks that we are talking about, and if you are currently representing somebody who's an importer, these are conversations you need to have. And if you are a student who's interested in entering the field, it's probably the most interesting time in a long time to be joining the customs bar. So, thank you.
Thank you so much, Larry, and thank you for the first panel too for two phenomenal programs. One thing to link the idea of these battles on classification to the battles on interpreting statutes is the progression of from Meads to Skidmore to Chevron is a progression that's tracked on based on how much process is given to the party appearing before the agency in that particular proceeding. And for my students, and I do teach you Chevron, and I do mention Mead, but you have to absolutely leave law school having taken the course in administrative law, so you understand this progression, because it is where the rubber meets the road oftentimes. Well, as our closing our morning speakers, we're going to have Judge Leo Gordon. He is a more than 10-year friend of mine. He was a judge who helped me actually finish my first article by providing me with 3 very important remand redeterminations that I could not find at the Department of Commerce. Judge Gordon is a graduate of Emory University. He's a phenomenal, has an encyclopedic knowledge of trade. He is as old as as in the trade court as I think 1980. You've been there as long as 1980?
January of 81.
81. And so he has some brief remarks before we break to lunch and we end the CLE portion of the conference. Thank you so much for coming. Judge Gordon.
No. Thank you, Usolino, for the kind words. So the single worst position to be at a conference is the wrap-up speaker. And since we're near noontime, I'm smart enough to realize that I'm the only thing between you and lunch. And if we're wrapping up at 5 o'clock in the afternoon, I'm the only thing between you and drinks and dinner. So I'm going to make this quick. I would say to you from a kind of 10,000-foot perspective about this morning is you were truly privileged to have experienced, knowledgeable folks who really know their way around the customs and trade world. And for that, I think we owe them a debt of gratitude and appreciation for all the time they invested in order to think about the topics that they brought to you this morning. So to them, congratulations, and thank you for imparting your wisdom to the folks here in attendance. The second thing that I would say to you, as probably the first takeaway from today, is that which is old is new, and that which is new is old. You know, right? I mean, you think about a lot of the things that were discussed today, and yes, there's new twists and nuances. Yes, there's some changes in the law, but if you take a step back, there's a lot that they're drawing on in terms of what's happened, what's come before. So, you know, even though the world changes in customs and trade law, whether it's here in the U.S. or internationally, we're not reinventing the wheel dramatically. Other takeaways I would say for those of you who are in practice here in the Midwest and or in-house, your eyes should be a lot more wide open than they used to be. There are a lot of things that maybe were out there and you knew about, but now you really have to pay attention to them. And there is a very significant intersection, probably more so than ever before, between the world of customs and the world of international trade. And even if you're immersed in the world of international trade, you know, in a dumping or a CVD, you know, a subsidy proceeding, the reality is policy is now crept in a way that has an impact on a day-to-day, your day-to-day business experience. And you know, it's your obligation to make sure that the folks who are making the business decisions, you know, that are on the same line as you or above you, really are much more educated about what's going on in the world of customs and trade law, because the consequence of not knowing is very significant today. For those who are students, the bottom line, I think the takeaway is, you know, if you're a jurisdiction and procedural wonk, there's work for you. If you're somebody who is tantalized by the course on administrative law, there's plenty of work for you. If you're thinking about litigation and you want to litigate in the customs and trade area, well, there's a lot for you. I would say, in particularly Judge Kelly, when she talked about a couple of the cases and the two panels, remedies. It's one thing to know that your client has a problem and you walk into, whether it's the administrative agency or the executive branch, you know, USTR, or you walk into court. It's one thing to complain about the problem. It's a very different thing to understand what you want at the end of that process. So if you're in private practice, if you're a student thinking about going into private practice, it's not just drafting the complaint or writing the brief. You've got to be able to communicate who the decision maker is, what you want them to do specifically. It's not enough to say, you know, I want an injunction, or I want mandamus, or I want this. You know, the Judge Rastani case is a perfect example, right? You need to understand what you want to walk away with on behalf of your client, whether you're on the plaintiff side of the V or the defendant side of the V. If you're tantalized by constitutional law questions, well, guess what? They exist in the world of customs and trade law. Maybe not in the way that one might traditionally think, but they're there. If you want to do policy, well, guess what? There's plenty out there in terms of the WTO. There's plenty out there in terms of country-to-country negotiations, as we saw in the USMCA. So the bottom line is to quote Larry, there are plenty of opportunities, more so now than ever before. It's not just siloed. You have to have, right, a very wide-angle view. Your day-to-day work may silo you in some respects, but if you're not aware on a broad perspective, you cannot serve your clients, you cannot be useful and meaningful to the partners for whom you work. So when you leave here, it's not only the specifics that the panelists talked about, but take that step back and think about the takeaways. What are the big picture things that will excite you, draw you to the area, and that you need to be aware of to better serve, whether it's the partners at your firm or the clients that you have, or if you work for the government, candidly for the agency that you work for. So with that, we're going to break for lunch. We're done with the CLE program, and thank you for 5 minutes of your time. I appreciate it.